afternoon or good morning, wherever you are in the world, and welcome to this live Betting on Brazil webinar hosted by Vixio. My name is Jack Halliday, and I'll be running the webinar. Before I hand over to today's speakers, I'd like to remind all attendees to please engage as much as possible by asking questions. You can do that by writing questions in the question box, and we'll get to them as soon as we can, and we'll dedicate some time at the end of the webinar to answer as many audience questions. If you have any audio or visual issues throughout the broadcast, please message in the chat box and a member of the team will get back to you. And also like to remind you that today's webinar is being recorded and a full version of the recording will be sent out after the webinar. Now, without further ado, I'd like to hand over to today's moderator and Chief Analyst for Vixio, James Kilsby. Over to you, James.
Thanks, Jack, and good morning or good afternoon to all of you who are being generous enough with your time to share an hour or so with Vixio and with our guest speakers on a Friday. For a brief intro to Vixio, for those of you who aren't already clients of ours, we are a RegTech company, and through our intelligence platform, we provide insights, analysis, reports, data, and a series of interactive tools that allow operators, suppliers, and other stakeholders to monitor regulatory changes, prepare to enter new markets, or respond to changing compliance environment across the global gambling industry. Do Jack want to move us on to the next slide? Specific to Brazil, our platform offers a dedicated regulatory tracker that provides a clear timeline of all the legislation, ordinances, and other documents that are now very much stacking up on top of each other, thanks to the hard work of Brazil's Ministry of Finance that we're due to discuss in the next few moments. Yesterday, we also published a new report that summarizes each of the ordinances as they are being rolled out. Last month, we also hosted a webinar to discuss some of Vixio's platform and our content related to Latin America. Through our platform, we have other tools that allow you to track partnerships in Brazil and other Latin American markets, to forecast the size of Brazil and other markets in Latin America. And we released a new tool this week that allows you to visualize and compare regulations across Latin American jurisdictions related to advertising and responsible gaming. Please do not hesitate to contact us for more information about Vixio and how we may be able to help you to enter new markets and respond to compliance changes in Brazil, Latin America, and around global markets. Now, we're here today to discuss the implementation of Law 14790 that was approved in December of last year to implement a national regulatory regime for online gambling and sports betting in Brazil. It will be no surprise and not news to any of us here today that since December, Brazil has become perhaps the hottest topic in the global online gambling industry, and we are seeing the emergence of a regulated market that Vixio forecasts will be worth nearly $5 billion in annual revenue by GGR within the next 5 years. On to the next slide. As you're probably also aware, and will certainly learn more about today, this is also very much an evolving situation. From Vixio's experience, I can certainly appreciate that what we often see in primary legislation or in laws are the cornerstones that will be within a regulatory regime, and then the devil turns out to be in the details of secondary regulations, technical standards, etc. That's fundamentally the case of what we've been experiencing in Brazil over the past 6 or so months. The situation as it stands, and we will talk more about today, is that a licensing process has now begun in Brazil as of 2 weeks ago on May 22nd with the release of an ordinance by the Ministry of Finance. And again, we'll go into some more detail, but fundamentally, operators have a 90-day period from May 22nd to apply for a license in order to guarantee that they can go live before the end of a transitional period that will expire at the end of this year. On the right-hand side of your screen, you'll also see that the licensing process is now moving forward at the same time as the regulatory regime is still somewhat of a moving target. That licensing ordinance was just the 4th of 11 planned ordinances that will be released by the Ministry of Finance and a new secretariat within the ministry, Secretariat for Prizes and Bets, or the SPA. It may be a term you hear later on. And the purpose of today's webinar is to discuss what we have learned so far from those 4 initial phase 1 ordinances, as well as from Law 14790 itself, and then get a clearer sense really of what to watch for and what to expect during phases 2, 3 and 4, which should be concluded before the end of July. Without further ado, it is my great pleasure to welcome back our two expert speakers. Luis Felipe Maya is the founding partner of Maya Yoshiyasu Advogados based in Sao Paulo. Luis will be familiar to many of you as he's a long-standing gaming law expert in Brazil and spoken at many international conferences on the Brazilian market since long before law 14790 was moving through the Brazilian Congress. We're also joined by Rafael Marchetti Marcondes. Rafael is the Chief Legal Officer for Rei do Pitaco, which is the leading Brazilian daily fantasy sports operator that is preparing to expand into the sports betting market. But Rafael also serves as legal director for the Instituto Brasileiro do Jogo Responsável, if I pronounced that correctly, or the IBJR, which has established itself, I think it's fair to say, as the primary industry trade association for betting operators and related companies that are seeking to enter the regulated market. Luis and Rafael, bienvenidos, welcome. You were both kind enough to join us on an initial webinar on the Brazilian market in December, which was so timely that we had to reschedule. It to avoid clashing with the Senate's vote on what ultimately became Law 14790. I do recall during our first webinar in December that you both had the foresight to flag some policy questions that were raised by that legislation and have sort of since been amplified over the past few months. And equally, I also recall you both were very cautiously but nonetheless optimistic that the Senate's decision to limit the regime to sports betting could be overturned by the Chamber of Deputies and would result in a fully regulated online gambling market, which is what transpired by 14790. So yeah, we certainly benefited from your wisdom and insight in December, and absolutely delighted to welcome you back today, 6 months on, and we have a lot to discuss. So much has happened in these 6 or so months since then. Brilliant. Well, so we're going to start the webinar. I am going to ask some questions for Luis and Rafael, but as Jack mentioned at the top of this webinar, please do share questions that you may have within the chat box. We will either weave those into our conversation or also save some time at the end to put them to Luis and Rafael. I absolutely encourage you to take advantage of Luis and Rafael's expertise as they join us today and have your questions answered. Well, great. I think to start off, Luis, Ordinance 827/2024, published on May 22nd by the SPA. That set a specific timeline for the licensing process, giving operators the opportunity to guarantee they will receive a license by the end of this year, but provided they submit an application within 90 days or by August 20th. Is that 90 days enough time? And how important is it that operators do submit their application within the 90-day period, given the nature of the transitional regime that's established?
Oh, hi, James. Hi, Rafael. Thanks, James, for inviting us again to be here. It's a pleasure. I think it's very timely since we had some very important developments in actually yesterday, and besides this ordinance for the licensing. Regarding your specific question on whether the 90 days are enough or not, I think it may be. I would say that most of the operators that were targeting the Brazilian market were in some way already preparing for this. If you see, the ordinance has a lot of documents required, but it's not that complex, and actually it's a pretty straightforward procedure. It takes a while to get the documents together, especially international documents that needs to be notarized and apostille translated. But at the end of the day, I think it's feasible. The most critical part for most of the operators, I think we had two different issues that were most critical. The first one was the definition of the 20% of mask equity that happened yesterday, and we are going to deal with that later on during this webinar. So I will not do any spoiler here. And the other one was that we see that some companies are struggling is to hire people in Brazil, especially international providers, because the ordinance states that the operator will need to have at least 5 people in key positions in Brazil, and these people need to be informed to the regulator. They need to send their qualification and so on. And out of those 5, at least 3 must be officers. They must be appointed as officers of the company.
Right.
So what we see now is some companies are struggling to hire the right people for those key positions.
So there is challenges with the 90-day period, but can you briefly explain? There's a high incentive to submit an application within 90 days rather than extend beyond that, right?
Yeah, I think the incentive is much higher for the companies that are already operating in the market, because if they fail to apply until August 20, they have no guarantee that their license will be issued until the end of the year. And since the SPA stated that the transition period ends on January 1st, meaning that after that date, no company without a license will be able to advertise in Brazil, to accept payments in Brazil, or to accept bets in Brazil, and that they will be subject to huge penalties, not only them, but anyone who advertises or processes payments for them. I think that there is a critical incentive for companies that are already operating in the market. Companies that are not currently in the market but intend to enter, the incentive is a little different. It's the chance to start operating on the legal market at the same date as all the other operators that are already targeting this market, because the regulator will issue the approval of the applications altogether. It's going to be a single decision where they're going to see all the approved applications and all the denied applications. So there is no race for the application right now. It makes no difference whether you apply today, tomorrow, or any day during the first 90 days. Of course, it will give you more time to answer to the regulator's requests for further documents or further information. But in terms of getting your license first, it makes no difference.
Yeah, August 20th is the key to watch. And a quick, very, very quick clarifying question. You mentioned, it's come from our audience, you mentioned the mandatory executive level positions that must be named within a license application, compliance, auditing, responding to the regulator, and I think consumer complaints representative. Those positions, those individuals must be based in Brazil.
The regulator created something that was actually very useful, which is a public Q&A, where they are going to disclose the answers to the questions that are being made by several stakeholders. I think this is a development that is very good because it gives more transparency to this process. And one of the answers was regarding this specific issue. So what they say is that the officers must be resident in Brazil. So out of the 6 positions that must be taken by 5 individuals, at least 3 must be resident in Brazil. The answer is not clear on whether the data privacy officer and the one in charge of operational security of the betting system, if those positions must be taken by individuals residents in Brazil or not. The most conservative approach is that they should.
Okay.
But that is still pending clarification.
Thank you. Raphael, what was your response to the licensing ordinance and the 90-day is there anything in particular from your perspective and from Hey Topitaco's perspective, is there anything problematic that you see within the licensing requirements, and what's your take on them?
James, first of all, thanks again for being here. It's always a pleasure to be with you and all the audience that Vixio has, and also sharing a panel with Luis. That's a great profession, great Brazilian professional. So for me, it's a unique opportunity.
And thank you for joining us.
And again, I think that we are in a very proper moment to hear, as you told in the very beginning, we have had many new things happening these last 6 months since our previous meeting. So I think that's a perfect timing, as Luis just said. And going to direct to your question here, I think that when we consider the license of ordinance, I don't see any big surprise here. I think that the whole process has been very transparent, and even the Q&A that Luis just mentioned is another proof of that. So all the operators that have been following all the steps that the Ministry of Finance has been given, I think that for them there is no big issue. I think, of course, there's always something that is new that we didn't have so broad clarity, but anyway, I think that in an overview, I think that everything is as expected, let's say like that. And for me, something that I think that should be raised here is about this transition period that we have in the law. The law, of course, established a minimum transition period of 6 months, but we didn't have some clarity about how it would be, what would be considered. And I do believe that here, the way that the ordinance foresee, basically we have more visibility that till the end of this year, to 2024, everybody that's operating in Brazil will have time to adjust themselves to the requirements that are coming, not only that were already foreseen in the law, but that are also coming in the current ordinance that have been released by the Ministry of Finance. So this is something that gives some comfort to the operators, in the sense that they may apply for the license, but they don't need to be 100% ready. Of course, they have to be working on the requirements, but they have time to do it. And I think that 6 months as a grace period is a very reasonable time for them. So this was something that called my attention in a positive way. And concerning other financial qualifications or license rules, I would say that was what we already expected, the license fee around that 30 million reais, around $6 million, up to 3 brands that could be explored under each license, some 5 million reais, that is around $1 million guarantee. So I think that everything seems to be very, very clear, the way that the previous discussions and notices released by the Minister of Finance mentioned before.
Okay. Thank you. Apologies if there's any sort of audio or visual disruption you might be seeing there. We are recording today across 3 continents, but I think it's clear that the licensing ordinance and the transition period that it established has some challenges, but well received, and the transparency that has been provided through the process so far particularly welcomed. You have both, I think, mentioned this, and we should get straight to an issue around the 20% requirement for each licensed operator to have a Brazilian that owns 20% of their capital. We had some important news on this less than 24 hours ago from the Ministry of Finance and the SPA, and we also spoke about this in December at a time when it wasn't entirely clear that this would be in the final version of the Brazilian legislation. Luis, can you explain why the 20% requirement is so fundamental for foreign operators, and I guess what yesterday's published response by the SPA, what that addressed, and what it means going forward as international operators consider how to apply and structure their operations in Brazil?
Let me just give a little background on this 20% requirement. This was introduced by the Senate during the discussion of the law, and it was approved in December. This was not something that came from the regulator, and it was quite unexpected. It was a surprise for the whole industry, the inclusion of that 20%. And the reason why it was unexpected is because, and I think we spoke about this in our last webinar, it's unconstitutional. In Brazil, you cannot differentiate between national capital and international capital companies unless in specific cases where you have national security involved. We raised that questions to the regulator, and there was a formal consultation on this, which resulted in the internal process for the internal attorneys from the Ministry of Finance. And finally, they agreed with our understanding that for this provision not to be unconstitutional, the only possible interpretation would be that a Brazilian company could be considered as a Brazilian shareholder, regardless whether that Brazilian company has Brazilian shareholders or foreign shareholders. So this was a huge problem for several international operators, and that if that was not the case, then 90 days would not be feasible, because it would be very hard to negotiate a deal with local partners and do the due diligence in time for the application. Now, all they need to have is a holding company in Brazil, holding at least 20% of the Brazilian company. It can be a holding company, a whole-owned subsidiary, owning 100% of the operation, and then that requirement will be complied with. So at the end, I think it was a very good solution. The solution that was brought by the regulator avoids litigation, because that was one of our concerns. Because if the interpretation was more restrict, I think there was a chance for litigation and even to suspend the whole application process with a court injunction. So I think now we have this in the past, and it became very easy for the foreign companies to comply with this requirement. But instead of having one company in Brazil, they need to have two.
Again, this is a question that we've received several questions about already. But to clarify that, your interpretation of yesterday's response from the Ministry of Finance is essentially that international operators based outside historically based outside Brazil, they will not necessarily need to have a separate partner in Brazil as part of their application, but they will need to establish a Brazilian company, and that has to be, if I've understood this correctly, that has to be a bona fide Brazilian company with headquarters and administration and the staff that you mentioned, among other things, in Brazil. It's just that there isn't a need to bring in a natural Brazilian partner that's either a company or an investor or an individual investor. Is that?
Yes.
So, Rafael, what was your take on the Ministry of Finance's answer yesterday, and with your IBJR hat on, how do you think the industry responded to that news?
In the same sense that Luis just said, I think that was a very good solution that avoid like a lot of judicialization. Probably this issue would be challenged in court. So the Minister of Finance in the end took, let's say, a smart decision to avoid litigation. And not only this, I think that this kind of bureaucracy makes no sense. Was introduced like with no clear, reasonable purpose. So I think that under the situation that was raised, the Minister of Finance find a good turnaround, and the IBJR position was the same as we just mentioned. We were of the opinion that the rule was unconstitutional, and this could harm just the international companies trying to bring some benefit for local operators that doesn't make any sense. So in the end, I think that most of the members of IBJR were happy with the solution. And I think that there is a specific point that wasn't clarified in the Q&A, and that may generate, not for everybody, but for a few, some doubt, is about if an individual holds the capital, whether they need to hold the stake directly or if this can be done indirectly. This was also an issue that could be addressed in the Q&A, and it was not. I tend to believe that once it was considered the possibility of having like legal entities, probably the regulator will require directly participation, but I don't know. I think that this could be some point that could be clarified, if not now, like in the near future, because some operators may have this doubt. And I just like to give a brief context why it took so long for us to have a solution for this issue, is because the Minister of Finance to take the position because they were waiting an input from the Office of the Attorney General of the National Treasury. So they make like a formal consultancy for them, and the Federal Attorney and the Attorney General of the National Treasury took more than desire to answer this question, what was done yesterday, and released an opinion about the issue. The Minister of Finance answered that question in the Q&A, and I think that's the reason why it took so long. But it would be very interesting, at least for the industry, to the grounds of this legal opinion. However, the Minister of Finance has already mentioned that they won't publish this document. So unfortunately, we will have to take to be with their answer.
That's great. Just summarize that in pause briefly there, but we're waiting for this answer because this was a legal and constitutional question that the Ministry of Finance formally consulted upon the Attorney General's office to resolve, and that's why we had an answer yesterday rather than necessarily within the licensing ordinance. But it certainly seems, I know from when we spoke about this in December, and since then, this was a kind of an essential piece in the jigsaw puzzle for how the Brazilian licensing regime would look, and it does seem as though we now have an answer to that burning question. I was going to move on to actually talking of burning questions, another one that occurs to me and is reflected in some questions that have been submitted. Of the 7 ordinances that are still to come, one of those will be establishing technical requirements for online games, jogos online casino games. This has also been a hot topic since late December, since January, since the law was passed. And I think that's because of the nature of online gaming having to fit under the banner of fixed odds betting, which is what Law 14790 and a preceding law has authorized. We have heard former government officials offer some indications that because of the nature of fixed odds betting and how it's defined, that may mean that certain types of jackpot games or even crash games could not be allowed in Brazil. And I'm not aware that this issue has been fully resolved to date. Luis, would you bring us up to speed on this situation and explain why do we have some degree of uncertainty around permissible casino games as fixed odds betting, and how do you see this? Do you see this issue being resolved via technical requirements ordinance for online games that is due in I think phase 3 or 4 in this regulatory rollout?
James, I think this is currently the most complicated point of discussion between the operators and the regulator. Let's keep in mind that we have a new secretary, and it means that some of the discussions that were already held between the industry and the former regulators, they need to be done again. And there are some doubts, according to, and I'm quoting the regulator. There was an event today in São Paulo where he said that he is not sure whether online casino games would fit into the definition of online games as defined by the law. I think I understand his caution not to take any position before he is certain of whether it is or it's not legal. I think it's important for the industry to keep on pushing and having meetings and showing technically that is what we call online casino games. And I think here we have the problem with the word, because there is still prejudice against the word casino, the word bingo, the word slots, which in Brazil, in Portuguese is called caça-níquel. There's a lot of prejudice over all this, and it gets in the way of the technical discussion, whether, because either it's fixed odds or it's full betting, and we also have some very bad press over some slot games like the Fortune Tiger game and some crash games. I think it's up to us now to show the regulator that one online game with multiple odds, depending on multiple potential results, fits in the definition provided by the law. The law states that the player must know beforehand the odds of the bet. That's the legal requirement. That the player must be informed before placing the bet the multiple, which will be the prize if he or she wins. And that's the case in most online casino games. That's the case in slot games. The fact that you have a table, a chart,
a pay table, right?
Yeah. It's still a fixed odds. It's fixed odds in that case, but they are fixed. They don't depend on one player playing against the other, or if one player wins, the other player has to lose. The result is defined by a random number generator, and the prize is the one defined in the rules of the game. So I know I didn't answer the question. I'm just showing how complex the discussion is and the status that it is right now. I think it's unclear. The more we hear from the regulator, the more uncomfortable we get. And I think this kind of uncertainty during the application process is not good. We have some clients that are applying, they're preparing to apply, but they will wait until they have more clarity on this point. And then it's important to highlight, and just to finish this thought, that if the regulator chooses a more restrictive interpretation of what is considered fixed odds and what is not, we have one big problem, which is channeling. Hero operators will apply for the license, and the black market will be huge. And we have the risk of litigation, because the regulator must define the requirements within the frame of the law. They are not supposed to create additional requirements, and then that could raise that will probably create room for litigation that may take even more time, potentially suspending the whole application process. So I really hope, and I think they have a very good team. Regis, Daniela, Marcelo, Andre, Renato, and the whole team. Forgive me if I'm not mentioning the name of everybody, but they have a very good team at the regulatory body right now. And I'm hopeful that they will make the right decision on this matter.
I think I'm aware that just yesterday the secretary spoke at another event, and he did seem to indicate that the team was also evaluating the regulations of Italy, where similarly online casino games are authorized under the guise of fixed odds bets. So yeah. it seems fair to say this is an open question still, and it's a fundamental. We talked about the 20% requirement being one fundamental question that we do have an answer to. This seems to be another one where we don't have one yet. Raphael, I guess if you could sort of share IBJR's and your own perspective on this issue, that'd be great. But also, do you anticipate, and Luisa, swing back round, do we anticipate to have an answer to this question as part of the planned ordinance? You can see it on the screen there, phase 3, technical requirements for online games. Is that where we expect this question will be resolved, and we will have a clearer definition of what types of online gaming will be allowed or not?
James, initially this clarification about what would be a fixed odd bet. Of course, it was kind of addressed in the system's ordinance, but I do believe that this is not the most proper place to be. It was even like expected some more clarity to come in this last ordinance, the license of ordinance. However, due to a lack of internal alignment, even in the Ministry of Finance, this idea was postponed. And for us, I think that's not a bad thing, because this means that we still have some room to work on the concept of fixed odds. And this is what, as an institute, we've been doing in the past month with them. We've been collaborating with the Ministry of Finance, providing elements to demonstrate that classifying crash games, especially that's our big issue here in Brazil, as fixed odd bets is something reasonable and in accordance with our legislation, as we just mentioned. But I think that like we may succeed or not, but the main topic here that has been addressed nowadays with the Ministry of Finance is exactly what you just mentioned, the Italian case, because there we have some similarity in this specific matter between the Brazilian and the Italian legislations. And we've been like the past meetings that we have with the Ministry of Finance, like the regulator, we've been discussing the Italian case, how Italy admit crash games, consider them like as fixed odd bets, and how this is authorized by the regulator. We've been even working with some law firms in Italy, and there are even the Italian regulator to have a paper in what we have like the main aspects of the Italian legislation and the reasons why under the Italian legislation crash games are accepted as fixed odd bets. I think that this is a way that the regulator seemed, at least till now, more open to hear, because initially the impression that we had is that he had like a similar understanding about what would be fixed odds as the previous regulator, Mansour. So the Italian case may be a key aspect in that discussion. And the main concern from what we could observe from the regulator is that when you think about like an aviator, of course, you have some visibility about the possibilities of that the game gives to the players. However, his concern is that even being in you have like a limited base of possible results. There are so many results that tend to be something unpredictable according to his position. The point that we've been working hard here is to say, look, we have to always be aware with the legal framework. So if the legal framework, as we just mentioned, comes with something like asking for clarity about the rules, previsibility, and these two requirements are fulfilled, we cannot create an extra just because it's something that gives many options. So if the legislation doesn't bring like any kind of restriction in that sense, saying that if you have to have like 10 possibilities, 200 or 10,000, the regulator just cannot do it. And this was in some sense like the understanding of the Italian regulator when they decided to admit the crash games as a fixed odd bet. So that's the way we've been working. Answering your question, I think there are still room to work in the concept, and we hope that we can succeed, because otherwise, as Luis just said, we are gonna lose channeling, and we are gonna increase the black market, what is bad for everybody, for the companies that intend to operate in the Brazilian market, for the government that will lose revenues. So we are not asking for something that is against law. We are just trying to show that the Brazilian law admits this kind of game under the concept of fixed.
Great. That's very helpful. I mean, clearly this is a key issue and an ongoing conversation. Luis, just specifically on the forthcoming ordinance phase 3, you can see on the screen there. Do you think is that where the regulator is most likely to address this question, or is it possible that we even see something like in the licensing ordinance where we had the answer to the 20% question that came subsequent to the licensing ordinance itself? How critical would that?
I think it's more likely that we'll see the definition and the technical requirements for online games.
Yeah, great. Well, I think that we have had many questions around this question. A related one that's also been submitted by several members of the audience, and perhaps a quick one for you, Luis, to clarify. There are no current requirements for suppliers or vendors to be licensed in Brazil. What's the landscape look like for suppliers?
So at this moment, there is no B2B requirements. There is no B2B license. What we have is the obligation for the B2C operators to have their systems and games certified by an accredited laboratory. So the certification will be done by the B2C operator, not by the B2B provider. What we see is we see several B2B operators starting to incorporate their companies in Brazil, incorporating subsidiaries in Brazil, not for a regulatory requirement, but for tax reasons. Since their clients will become Brazilian companies, will be based in Brazil, it is very expensive for a Brazilian company to pay international services. The additional taxation is over 40%. So in order to have competitive prices, the B2B operators are creating subsidiaries in Brazil, but that is not a regulatory requirement at the moment.
Great. I want to ask as well about one other pending issue, and then go to some additional Q&A. We also flagged this. I say we. You guys flagged it in December. There is a statutory prohibition on bonuses within the law. However, you both made the argument in December that a very reasonable interpretation of the law was that welcome or acquisition bonuses would be prohibited, but retention bonuses may still be permissible. It did appear within the ordinance that set technical standards for betting systems. There was a definition within that ordinance that introduced the concept of loyalty programs and specified that loyalty programs would involve transactions that were incentives provided to customers. Fundamentally, the question is, do we ultimately anticipate that retention or loyalty bonuses will be allowed in the Brazilian market, but not customer acquisition bonuses. Luis can take that one.
So let me put it like this. Retention and loyalty incentives will be allowed, bonuses not.
Right.
Don't call it bonuses.
Okay, but conceptually, as a marketing opportunity for operators, there will be ways of rewarding players. I guess this is also an area we may expect some additional definition, and operators will have to respond to that. But
I think the ordinance for rights and obligations may bring some details on that. Basically, I think the intention of the legislator here, and we see the regulator maybe with the same intention, is not to allow welcoming bonuses, basically not allowing operators to offer hundreds or thousands of reais for people that are not players to become players. Because that has been quite frequent in Brazil, welcoming bonuses. This is a common practice in the Brazilian market to attract new players. So welcoming bonuses will definitely not be allowed. So when they call it a loyalty program, what they're saying is basically between the lines is that you can offer incentives for your existing clients based on your relationship with them. You cannot offer bonuses or incentives to people, to new players or people who are not your client, just for them to become your
clients. I have a specific question that is around what was an important component. We mentioned the ordinance, the betting systems, data storage, data localization, and whether or not operators will be obliged to have their systems and store their data in Brazil. Rafael, take this one briefly, but where do things stand on that front? If I'm not mistaken, the regulation does allow for data and systems to be outside of Brazil, but there are quite significant caveats to that. Is this an important issue that you see going forward?
I think it's an important issue, but I don't see like lots of difficulties for most of the operators, because that the law, as you told, requires having a database based on Brazil, but also gives the opportunity for keeping it broad once the Brazilian government has an agreement, a collaboration agreement with the other country or jurisdiction. So this is something that can be, like, I cannot say easily solved, because this agreement is not like with all the possible jurisdictions, but the main ones, especially like US, when we have like many servers, this is something that that will work. Of course, maybe some relevant jurisdictions as Malta doesn't have an agreement with Brazil, and this may cause some pain for a few operators. But in the end, at least in my opinion, I think that this is something that's manageable and doable in the 90 days window that the government has offered, the initial 90 days window that the government has offered for the market.
Luis, anything to sort of add on that subject?
What we hear from some clients is that this may be an issue because their servers are placed in countries that do not have this kind of criminal and civil cooperation agreements with Brazil, and that it wouldn't be easy to move the whole system, the whole structure to Brazil or to another country, because they operate all countries, they operate in the world from a single location. I think this is, in terms of technical requirements or operational requirements, I think this is an issue. And we need to understand what is behind this. And I think we need to reason with the regulator that the fact that there is an agreement, legal collaboration or cooperation agreement does not mean that they will have instant access to a server elsewhere. So it doesn't make much of a difference whether it is placed in a country with a treaty or not, as long as they have the power. First, the ability to access the data, so the mirror server being in Brazil, and to shut down the operation. I don't see any reason why these should be a requirement. And also the 120 minutes to pay the prices. This is quite excessive. When you have huge prices, or when you have some doubts regarding potential fraud or latency issues or whatever, you need to be able to withhold payment for longer, much longer than 2 hours. So I think, and I'll ask you, James, because you know several other jurisdictions. I'm not aware of any other jurisdictions with such requirement of having to pay all the prices within 2 hours. Do you know of any other one?
I am not aware of. I'm not aware of any that jumped out to me reading that ordinance. But then equally, you know, there'll be compliance and legal representatives of operators and suppliers on this webinar who may be aware of some precedent for that. But it certainly, it seems you know, that may be a unique requirement. Thank you for flagging it. We are coming up on the top of the hour and are very short on time. I think it's fair to say we could probably spend several more hours digging into the ins and outs of the licensing process, the regulatory process. But for those attending, particularly in Europe, I'm conscious that it's now eating into a Friday evening, and the weekend has begun already. So I just one final question as we kind of go into overtime. Luis, you flagged the 120 the 2-hour payout requirement. Is there anything else, Luis or Rafael? Maybe Rafael, will start with you. Is there anything we haven't spoken about today that you think we should highlight as a pending issue that operators, suppliers, and other stakeholders really do need to be aware of and watch out for in the next, you know, within what remains this 90-day period in the remainder of the year? Anything we haven't spoken about that is pressing that you could briefly flag and maybe tease our audience to come back for more later, and we can go in more depth.
Rafael, do you want to start?
Yeah, I can start. Thanks. And before just ending my participation here, I think that it was great to be here again. And for me, I think that I cannot say that it's a very big issue, but there is something that sometimes seems to me to make it, I don't know, I cannot say no sense, but I don't know if it's something that the government will be able to manage. It is the amount of data that they are requiring from the operator. When you analyze the authorization ordinance or the licensing ordinance or even the systems ordinance, you see that is a huge amount of data that they are demanding from the operator. And I think that's doable from the operator side. My question here is if they will be able to manage all that information in a way that could be profitable for the government in terms of help them on fiscalizing the operation in Brazil. And another issue that calls my attention concerning this matter is that technically speaking, besides of these, the government requests like some blocks of information that you have to upload in their system, and the size of these blocks are small for the amount of information that they are requiring. So this will demand a little extra effort from the operators, but nothing that couldn't be done. But I think that's my final concern here, and I hope that the government can make use of all that information that they are requiring from the operator side.
Luis, any sort of final issues as a teaser that you could share with the audience here? You think we haven't had time to address today, but you think is worth more exploration?
Sure. And again, thank you for the invitation to be here. It's always a pleasure to be with you, James, and with Rafael. I'm a big fan of Rafael, he knows it. So I think the fact that the operators will need a .bat.br website to operate in Brazil, it's something that may create an operational issue, because according to the ordinance, once the application is approved, the companies will be able to get their .bat.br domains. But they will not be, and then they have 30 days to do that and go live, which is a very short time to test, to do DNS tests, to do all the technical adjustments necessary for the website to operate under a new domain. Right. So I think the regulator should consider allowing the applicants to start testing on those domains without access to the public.
Yep.
As soon as the application is made. I think this is an issue, and the other one is one of the policies required is the liquidity policy, and there is absolutely no standard and no information on what is required in the liquidity policy. And at this moment, what we have is the operators, they must provide the regulator with some declarations, some affidavits that their policies comply with the law and the regulation, AML policy, responsible gaming policy, and so on. But the regulation doesn't exist.
Yeah, coming later, right?
Yeah, it's coming later. So now we have a situation where, in order to apply, the regulator must declare that their policies comply with something that they don't know.
Yeah, yeah.
And this, I think, it's quite peculiar.
Yeah, that is certainly many moving parts. I am afraid we're going to have to stop us there, because we have already run into overtime. As I'm sure we could spend happily another hour at least going through other points here. There have been a number of additional questions that were submitted on Vixio's behalf. We will do our best to get back to those of you who submitted them. I'm sure Luis, Rafael, things that are very sort of specific to things you mentioned, we will touch base with you and try and satisfy those questions. I think your expertise is in very high demand during the course of this webinar, so certainly take that as a good thing. One final time, Luis and Rafael, thank you so much for joining us and sharing your insights. Given the nature of the Brazilian process, and they're both extremely busy these days, so to give up an hour of your time to share with Vixio and to share with the audience today is truly appreciated. So thank you. And on behalf of Vixio, thank you to everybody. Likewise, giving up an hour on a Friday afternoon, evening in some cases, depending where you're based. I hope this was informative. I've learned a ton just in the past hour or so. So Thank you all for joining. Thanks to our speakers, and I will pass back over to Jack for just a few brief closing remarks.
Thank you, James. Thank you, Raphael and Louise, and thank you everyone for attending today's webinar. As mentioned at the start of the session, the webinar was recorded and a video will be sent to all attendees in the coming days. Now, before I sign off, I want to remind you that Vixio will be closing the nomination platform for our 8th annual Global Regulatory Awards next week. So those that are interested, please make sure you get your nomination submitted before the deadline on June 14th. Please visit Vixio. Please visit gamblingcomplianceawards.com for more information and information on how to enter. Finally, if you have any questions about anything discussed in today's webinar or would like further information, please email info@vixio.com. Thank you.